Good afternoon, everyone. I'm Damon Hewitt, President and Executive Director of the Lawyers Committee for Civil Rights Under Law. Whether you're a longtime supporter or a new friend to the Lawyers Committee, I want to thank you for joining us today. I also want to thank you for being with us in this ongoing fight for a more just and equitable democracy. I don't need to tell any of you just what a dangerous moment this is in our nation's history. We face dire threats to our people, to our most sacred rights, and to democracy itself. In 2025, these threats came at us from all directions. The attacks on our rights came from states, they came from private actors, like they always have. But then, beginning on day one of this new presidential administration, they came directly from the White House in a form we've never seen before. They also came from the Department of Justice. And they've been weaponized like we've never seen before. We're in a moment when power at every level is being tested. Systems are being tested, infrastructure, checks and balances, concepts many of us took for granted for so long. There are coordinated efforts to obliterate civil rights protections that have stood for decades, efforts to bully people and individuals and entire institutions, and to silence communities. Overall, there's a concerted effort to make people believe that the progress in racial justice and equity of the last several decades was somehow a mistake. Together, these forces aim to weaken the political power of Black people and other people of color. They aim to simultaneously erase our shared history, but also derail our common future. They want to suppress our votes and silence our voices. They aim to close the doors of opportunity after we fought for generations to force them open just a crack. But we're not retreating. We're organizing. We're litigating across the country. We're defending voting rights. We're shaping groundbreaking legislation. We're building the legal infrastructure that this moment in the future, frankly, requires. And we're also demanding that the promise of equal justice must mean something to real people in real life, in real time. In that spirit, I want to take just a moment to honor the life and legacy of the late Reverend Jesse Jackson, who passed away earlier this week. Since his time working alongside Reverend Dr. Martin Luther King Jr., and for decades since, Reverend Jackson was a constant voice and presence fighting for equal justice. He was always there when we needed him. His time on this earth has ended, but his legacy endures, and we will see to it that his great work continues. Now, on to our program. Today, we're here to show you just how the Lawyers Committee is fighting back. But we're also here to show you how we're fighting forward. You'll hear from some of the people on the front lines of that fight, some of our courageous clients who are standing up for their rights and their communities, our fearless litigators who pursue justice in the courts, and our policy advocates who are leading the push for transformative legislation in the halls of Congress and beyond. In today's program, you'll hear about the urgency of their work. You'll hear about our leadership in the field, and you hear about our impact, the concrete ways that our work is making the promise of a thriving multiracial democracy real for everyone. Today's program is structured as a series of conversations, reflecting on how our work is relational and also building around partnerships with the communities we serve and with all of you. It's only through partnership that we will find the strength, the inspiration, and the resilience to meet this moment. In our first conversation, we'll talk about the people who are being targeted and harmed by the Trump administration's war on so-called illegal DEI. We'll also talk about how the Lawyers Committee is fighting back to protect diversity, equity, and inclusion, and winning. Our second conversation will dive into the current and coming threats to voting rights and democracy. You hear from one of our clients, a living legend out of Texas, who's been fighting for racial justice for decades, and who gave powerful court testimony in our challenge to Texas's discriminatory and racially gerrymandered voting maps. You hear about how we're getting ready for the threats around the corner as well. And finally, leaders from our digital justice and public policy teams will give you a window into our work on emerging technologies, artificial intelligence, and digital discrimination. The Lawyers Committee is using the power of cutting-edge litigation to protect the people who are most harmed by digital discrimination. We've been at the leading edge and a champion of legislation that can create real transparency, strong safeguards, and meaningful accountability. We'll have a Q&A period before we close, so we invite you to submit your questions for our team throughout the program. You can share your questions in the box at the bottom of your screen. Now, our program will confirm today what we're all feeling, that the stakes are as high as they've ever been. The threats are relentless, but as our speakers will tell you, we're relentless too. Together and with your help, we will never stop fighting to protect the voice, power, and opportunity of Black communities and other communities of color. And in the process, we will make our democracy stronger for everyone. Now, on to our first conversation. In 2025, the Trump administration issued executive orders aimed at dismantling diversity, equity, and inclusion programs and initiatives across various sectors, including inside of federal agencies, but also programs led by government grantees and contractors, often even if they weren't being operated with federal funds. These executive orders falsely claim that any practices or activities promoting equity and inclusion and diversity were somehow illegal. Now, the premise behind those executive orders was patently false, but the impact was swift and devastating. Across the country, law firms, corporations, and nonprofit organizations were faced with the catch-22, either stop their mission-critical work or in risk enduring the wrath of the administration and potentially losing vital access and funding if they didn't comply with these extra-legal demands. One of the organizations faced with this threat was Chicago Women in Trades, or Hewitt for short. Hewitt paves pathways for women, especially Black and Latina women, to enter and build careers in high-wage, skilled trade jobs. This organization, based in Chicago, but with a nationally impactful and well-replicated model, has made a difference by standing up as the plaintiff in one of our most important current cases, Chicago Women in Trades v. Trump. I'd like to introduce Hewitt's executive director, Jane Villenga, and also the director of our Economic Justice Project here at the Lawyers Committee, Katie Euchre. Welcome, Jane and Katie.
Thank you.
Right.
Thank you.
So, Jane, please set the stage for us. Help us understand why was it so important for you and your colleagues and members at Hewitt to take a stand by taking the Trump administration on in court?
Yeah, so just briefly, I guess, who we are. We are, I guess, the best way to think of us is like a mutual aid association for tradeswomen. So we were founded by and for tradeswomen for the purpose of improving women's economic equity by giving them access to high-wage careers, high-wage blue-collar careers in the construction trades. And we address this from all angles, really. So it's direct service programs to prepare women to be successful applicants. It's policy advocacy to eliminate systemic barriers to their participation, technical assistance to support industry stakeholders in building their capacity to recruit and retain women, and a host of other things, including community building and retention services. We've experienced a lot of success over the years, but as Damon was relating, this has been painstaking, inch by inch success. And we've worked long and hard to get to where we are today. And we were building momentum. These last few years have been some of the best in my history, my 26-year history at Chicago Women in Trades. And just as we were really seeing the fruits of our labor show up in the numbers of women participating in the industry, we basically had the rug pulled out from under us. And, what was once deemed necessary and worthy of investment was now immoral and potentially illegal. So anyway, the first week of the Trump administration, the very first thing that happens is that he rescinds the only goal for women in the construction workforce for federal contractors. And a few days later, we received notices from all of our funders saying that all of our federal funders, that our grants would be canceled if found to be in conflict with these anti-DEI executive orders. And that is our purpose, actually, diversity, equity, and inclusion. So very confusing. What is illegal about what we're doing? So this was federal funding was about 40% of our budget at the time. So existential for the organization, but also for tradeswomen who already have a difficult time finding work without the federal government threatening contractors if they do anything intentional to recruit a diverse workforce. So we felt like on behalf of our community, we didn't really have a choice but to try to fight this. And thanks to the Lawyers Committee, we're able to do that.
Well, thank you, Lawyers Committee, our co-counsel at Allied Organizations, and also the law firm Crow and Mooring stood together. And Katie, you are, taking the lead in our organization on the legal team side. Tell us about the recent win in this case and why it's so important, but also tell everyone about the current status of the case and what we can expect next.
Thanks, Damon, and thanks, Jane, so much for being a part of this webinar today. So leading up to the case, the Lawyers Committee had already been deeply enmeshed in protecting diversity, equity, and inclusion efforts. And at the time, what was mostly private litigation that was being brought around the country to dismantle such programs that were having a real impact in people's lives. And we knew that with the incoming administration that some kind of attack on DEI would be a day one executive order, and it was. We saw two executive orders issued in the first 2 days of the administration. And at that time, we started aggressively pursuing outreach to federal grantees to learn how these executive orders were being implemented and how they were being felt by organizations that were doing the very, very critical work that, like the kind that Jane just described. We were very fortunate to get connected with Jane and hear about their work. And she shared with us the communications that she and her team had been receiving from Department of Labor almost immediately within days of the executive orders coming down, threatening to defund or to deny reimbursement for any work that was, quote, diversity, equity, and inclusion related, without defining what that means. And as you just heard Jane say, that is what they breathe, that is what they do, is diversity, equity, and inclusion work. So we, along with Jane, agreement and brave, courageous decision of her organization, prepared a lawsuit to challenge the executive orders directly. We brought a number of constitutional challenges to those executive orders, and there were two key operative provisions of these very broad anti-DEI executive orders that we challenge here. The first is a certification provision, which requires all federal grantees and contractors across all federal agencies to certify under penalty of liability through the False Claims Act that they do not engage in any programs promoting diversity, equity, and inclusion that violate anti-discrimination laws. And so there are two particularly pernicious aspects of that provision. One is that it, on its face, hits and covers their privately funded work. So it's a blatant free speech violation. It's not just trying to rein in federally funded work, but also any work that this organization does if it touches federal money. And it also just doesn't define what is meant by DEI, but other parts of the executive order call it immoral and illegal, and use other words to associate with DEI that just flip the purpose and the intent of these programs on their head. And so it put grantees and contractors in this really untenable sort of Hobson's choice position where they either forego signing the certification and lose access to funding that is providing a way to provide these life-changing programs for local communities, or they certify and subject themselves to the uncertainty of a potential investigation or worse under the False Claims Act. And the other provision that we are challenging is the termination provision, which calls for across the board all quote unquote equity related grants and contracts have to be terminated. And so we challenged those, and the district court in the Northern District of Illinois granted Chicago Women in Trades a nationwide injunction, which protects all federal Department of Labor grantees and contractors from having to sign that certification. And it held that that certification provision violates the First Amendment rights of Chicago Women in Trades. for sort of the reasons I highlighted already. That injunction has been in place since last March and has been protecting all DOL grantees and contractors across all the Department of Labor programs since then. The Department of Labor, the government appealed that injunction. It first tried to get it stayed, meaning, and just for the non-lawyers in the crowd, injunction just means that the court ordered the Department of Labor is prohibited from enforcing the certification. So it's basically can't do it. And then the government asked the court to just hold off on this injunction and not implement it and let it go ahead with the certification requirement while it pursued an appeal. The district court denied that request. And also at the same time, again, reaffirmed that a nationwide scope for the injunction was appropriate for Chicago Women in Trades, given the nationwide scope of its work. So it's a kind of one of the only, it's really the only nationwide injunction on constitutional claims that we have found post Casa versus Trump, the Supreme Court decision last year that severely reined in the ability to get nationwide injunctions through constitutional claims. And we also, the court also granted an injunction as to Chicago Women in Trades regarding the termination, the equity-related termination provision. So Chicago Women in Trades will not, while the case is at least pending, at this juncture, face any termination of its grants or contracts pursuant to this order. And the court there found that it violated, that provision violated the spending clause and the separation of powers, because it's really for Congress to decide how to spend money. And it appropriated the money that was authorized through the program that provided grants to Hewitt. The very purpose of that money was, it had a very, very explicit equity related purpose, namely to increase the number of women in the skilled trades. And so the court found that this executive order that calls for the termination of that provision was in direct conflict with the congressional intent. And so we continued to litigate the case at the district court level and at the appeals court. We're now in discovery, and we argued the case with our pro bono partner at Kroll and Mooring at the end of January. We were so pleased that Chicago Women in Trades joined us, as they always do, in hearings at the courthouse, and the courtroom was packed with tradeswomen. And we were so very honored to have their support there. And we think it went well. We presented our side very well, and we'll get a decision in the next couple of months from the Seventh Circuit.
Thank you, Katie. Just so many important through lines and creative strategy. I didn't think a year or so ago that we'd have to argue that there was some usurpation of Congress's authority, that we have to defend Congress because it barely won't defend itself. But also just really interested in how over the last few years, with so many things that are really First Amendment violations by states and the federal government, we as racial justice litigators and advocates are using the First Amendment as a tool to advance racial equity, which not a lot of people wouldn't think of offhand. So really important work. Jane, let me come back to you. You said, you had to fight tooth and nail. It's a saga. I'll just draw the factoid that, the part of the injunction that isn't nationwide is about protecting from grant termination. And it turns out that the grant that is at issue, in particular in this case that Katie described, is called a WANTO grant, Women in Apprenticeships and Non-Traditional Occupations, WANTO. It turns out the other more than a dozen or so WANTO grantees from the Department of Labor all had their grants terminated. That money is gone. And it puts them in a really difficult position, I'm sure. And so I just want to come back to you, Jane, about the courage that you and your members and colleagues at Hewitt have shown by fighting back. What message do you hope that your fight back sends to others who are under threat? And also, if you can elaborate more on what it means to work alongside the Lawyers Committee in this case.
Yeah, thank you. So I don't know if we think of ourselves as particularly brave here because we're called Chicago Women in Trades. And so I think we felt that we were going to lose these grants no matter what. And so we also didn't want to be complicit, right, in normalizing attitudes that we've been fighting against for more than 40 years. So it was pretty clear, but the idea of fighting back was really just a theory until we met Katie and Sabrina on a Zoom call, and it started to become reality. Uh, so I guess what I want other organizations, I hope they feel emboldened by this. We're a small nonprofit. We're not experienced litigators. This is a novel experience for us, really, and we've made a big difference. And so I hope that that's emboldening for people. It is, they're counting on us to be compliant, right? But we're winning. And that means these cases are winnable. And we do not have to accept this sort of upside down worldview that they're trying to impose on us. And I really do think that the more people who stand up and fight back, the easier it will be for all of us to resist this change in our culture. Because it doesn't have a strong legal basis, right? I think the other thing I want people to know is that Chicago Women in Trades has not paid a heavy price for our stance. In fact, we were able to keep a grant that we know for a fact we would otherwise have lost. So I can't see into the future, but I am feeling like the risk is not what it appeared to be on the front end, right? I think the other thing is that the Lawyers Committee has been absolutely amazing. So this was an intimidating thing for us, but the staff from the Lawyers Committee and the amazing team from Kroll and Mooring have held our hands through this entire process, made sure we understood exactly what was going on, were patient and generous with their time through our sometimes cumbersome decision-making processes. Also thoroughly impressive from beginning to end, from the initial complaint to the briefs to the courtroom arguments, everything just a legal dream team. We feel like we're in excellent hands. And they tell our story very, very well. And we're very proud to have them represent us and to be part of a nationwide strategy to make a difference in other people's cases. To have this kind of coordination going on makes us feel like whatever risk we're taking is well worth it.
Thanks so much, Jane. It's been just a pleasure, and I've so enjoyed getting to know you and all your colleagues at Hewitt. Katie, we just have just a few minutes left in this segment. Tell us a bit about some of the other work we're doing at the Lawyers Committee, you and your colleagues are doing to advance diversity, equity, and inclusion, to protect it, and the impact that it can have even beyond the litigation.
Sure. Thanks, Damon. We continue to support programs that are advancing diversity, equity, and inclusion, as we have vigorously for many decades, really, because diversity, equity, and inclusion is not anything new, right? It's just a continuation of integration efforts, and it's very, very. It's a very big priority for our organization. So we have devoted really most of our team's work and across the organization to standing up litigation, amicus support, also public education, and policy advocacy to push back against this current backlash on racial progress that we're seeing. We recently filed another case challenging the anti-DEI executive orders on behalf of Freedom Network USA, which is the country's largest network of anti-trafficking advocates and service providers. And Freedom Network is getting 70% of its funding from Department of Justice federal grants that are authorized by the Frederick Douglass Trafficking Victims Prevention and Protection Act, which are all at risk, and they're facing extreme censorship. So they were actually sent a list of 50 forbidden words that could not appear in any of their materials, including words like race, gender, and discrimination. This is our government telling folks that they cannot utter the word race. So, these organizations, we anticipate continuing this fight on behalf of other organizations as well that are either facing government intimidation through the conditions that the federal government are placing on federal funds that organizations and communities rely on to do really groundbreaking and life-saving work. So we stand committed to upholding these efforts and helping all of us continue on our path to building a fair and thriving economy. So back to you, Damon. Thanks.
Thank you, Katie. Just want to again give kudos to your team. In addition to all the work you described, we also have a number of resources on our website, laurierscommittee.org, that span the gamut from advice to people in higher ed and K through 12, to corporations, to grant makers and philanthropy on how to understand where the law is and where it's going, and how they can navigate in the circumstance. And we also, just to remind our audience, we also have stood up for over 2 years now a unique, one-of-a-kind initiative called Protecting and Advancing Diversity, Equity, and Inclusion, or PADEI for short. Through this initiative, we take referrals from people that are trusted sources in the advocacy community and philanthropy and elsewhere to help provide attorney-client privileged advice to smaller nonprofits, scholarship programs, pipeline programs, even some public charities, even some CDFIs who want to understand, how do we navigate in this environment? How do we advance our mission given all of these attacks that are happening on our mission and how we move? And so we've now taken referrals from over 200 of those types of entities, and they rave about the advice our team has given. Now, all of them mature to litigation, certainly like Hewitt, but we're ready to litigate and fight if we have to. So thank you again, Katie. Thank you, Jane, for all that you're both doing. To learn more about Hewitt, Jane's incredible organization, please visit www.hewitt.org. That's hewitt.org. Thanks, Jane and Katie. Take care.
Thank you.
All right. So this past year, we also saw the Trump administration wage a war on voting rights and democracy, frankly, opening up new battlefronts in that continuing war that's gone on for decades, because we know that as long as we've had elections in this country, there's been racial discrimination and voting, voter suppression, and limitations on access to the ballot that are simply unconscionable and unsupported. Our team is fighting back against this assault on the Voting Rights Act itself and on the political power of Black voters and other voters of color. From Texas and Mississippi to Georgia and Pennsylvania, our lawyers are taking on the state, federal, and private actors who seek to silence the voices of our people and weaken these communities. One of the most common threats we're seeing is racial gerrymandering, often under the mask or guise of partisanship. I'm proud now to turn the floor over for the next conversation to one of our talented litigators, David Rollins-Boyd, and also Ms. Linda Lewis, Political Action Chair for the NAACP's Texas State Conference of Branches, and a key witness in our Texas redistricting case, or cases, as you'll hear. David, over to you.
Thank you very much, Damon, and thank you all for being here, and also thank you to Linda Lewis for joining. Just to kind of set the stage for our discussion, in 2025, the Lawyers Committee, in conjunction with our pro bono partner, Deckert Law Firm, represented the Texas State Conference of the NAACP in not one, but two cases challenging Texas redistricting efforts. In May and June of last year, we had a trial regarding Texas's 2021 State House, State Senate, and congressional maps. And then as soon as that trial concluded, the state began engaging in mid-decade redistricting to redraw its congressional plan. That led to a second round of hearings in October, where we sought a preliminary injunction to stop the use of the newly created map. Part and parcel to that, the testimony and work we did there was the great testimony of many individual members of the Texas community, the Black community, including Linda Lewis, who joined and spoke about the history of voting in Texas, the work the NAACP is doing in that space, and the impact of redistricting on Black and Brown voters. And so now I want to start my conversation with you, Linda. And before we really dive in, can you just take a few moments and introduce yourself to the audience? Can you let them know who you are and a little bit about your history in the space of voting rights, civil rights, and racial justice work?
Yes, and I want to thank the Lawyers Committee for inviting me to this very important sharing of information. I'm a fifth generation Texan, and I grew up in segregated Waco, Texas. My mother's sister lived in Austin, Texas, and she was one of the early Black women who already had a bachelor's degree that went to the University of Texas for 10 summers to get the master's after Sweat versus Painter. So I grew up knowing about Sweat versus Painter, that it took Thurgood Marshall 4 years to even open the doors at the University of Texas. I lived in a totally segregated community, school, church, home, community activities. And I was raised to know that it was my assignment to be ready when integration came, because it was my duty to be a credit to the race, to show those folk that we're just as smart and just as capable. So in 1965, I graduated as the valedictorian of George Washington Carver High School. I spent most of my school career from 6th, 7th grade through graduating, being involved in student government. I learned in high school that if you have a voice and a vote, you can change policy even at your school. The summer before I graduated, Texas Attorney General Wagner Carr decided that he would integrate boys state, girls state. That's where high school leaders from all over the state come and have a mock state legislature. I was hooked. When I registered for classes the summer of 1965, Lyndon Johnson signed the Voting Rights Act. Although I had to wait until I was 21, I was involved with both I joined the Young Democrats at UT and the NAACP branch at UT, and we were out registering folk to vote and couldn't even vote ourselves. My life and my experiences as being a baby boomer, an early integrationist, I was privileged to be one of the first Black women to run elections in Texas. From 1992 to 1996. But my life has been dedicated to making a change for me, my people, my Latino cousins, and for women. So having said that and knowing that I'm in this, I want to give a hat off to the Reverend Jesse Jackson, because I know, yes, we can. I know all we have to do is keep hope alive.
Thank you, Linda. And that actually leads me directly into my next question, right? Last year, as I mentioned, we had trial about Texas maps not once, but twice. And you came and you gave your time and energy to testify, to share your story with the court so that they could see the human impacts of redistricting and the cost when racial gerrymandering occurs. And I just was hoping you could explain to us, understanding your history, I think I know a little bit of this, but can you just explain why it was important for you to not only work in this space, but come and testify at the court so they could hear your story?
Well, it was really important because for 25 or more years, I've answered the on the ground, if you will, Texas voter hotline, voter suppression hotline. I typically answer the questions before we refer them to the Lawyers Committee or LDF, because voting in Texas is so diverse. You want to talk about diversity. We have 254 counties, and The county commissioners or the county clerk runs elections. Tax assessor, if you don't have an election administrator, the tax assessor is the voter registrar. So imagine 254 counties, and each county sort of handles it differently based on who the politicians are at the commissioner's court, who the elected officials are. And so it's really important for me to share some of the real world questions that come to me on our local hotline before I shut it off and pass it on to the 1-866 Our Vote, and so people can be addressed. Texas has just bloomed in terms of population, in terms of suburban growth, and people are really confused about where do I vote, who do I vote for? And that was with the lines for the 2021 census. And then on top of that, the Texas Republicans in their wisdom drew some new lines in areas that impact Blacks and Hispanics, doing away with 5 districts, cracking and packing those districts. And I wanted to share with that judge panel the questions and the phone calls that I receive, that I try to hand off to people who are just trying to vote.
All right. And actually, that reminds me of your testimony. I think you testified at court about getting calls about voter intimidation, voter harassment, disenfranchisement, mis and disinformation. And you talked about your life and your history fighting those things. And so can you just kind of explain how this particular case, this redistricting case, fits into the history of kind of like the voting rights work and civil rights work in Texas that you've been a part of?
Yes, I think that, we've been changed. Districts have been drawn to exclude us. By the time we figure out how to win a district or a seat, then they come and crack and pack it again. There are those who say that Texas is the laboratory for bad government. And as recently as 2018, your Demario Solomon Simmons had to come to Waco at our request because we were electing the first woman to the McLennan County Commissioner's Court. And there was so much voter intimidation from the other side. People drove through the polling place in the Black community was on historic Paul Quinn campus. There were cars driving through right in front of the polling place with Confederate flags, both during early voting and on election day. The candidate's wife complained because the Black election judge was just doing her duty. The candidate's wife was actually campaigning inside the voting room. The consequence was that the Black election judge's license plates and car were shown on the evening television. She has since quit. She's refused, and she was someone who grew up, as we say, in the election business. Her mother was a judge before then and an NAACP president. So the point is this: voter intimidation, voter disinformation, and racism is still rampant in Texas, in several Texas counties. And I've been involved with hearing some of those things and then handed it off to the lawyers or to the election administrator or whoever can change that. It appears that it continues to exist because this year, with the March 3rd primaries in several Texas counties that have large people of color populations, the county commissioners have decided that on election day, that people will have to go back to their neighborhood polling place on election day rather than vote anywhere there's a polling place during early voting. The challenge is the way Texas has just expanded in population. We are now a 60-40 state, which means that 60% of the population is Black, Latino, Asian, and other, and only white Caucasian are 40%. And the way people work with all of the construction that's going on, it's going to be virtually impossible for people in metropolitan areas and in suburbs to go back to their neighborhood polling place that they probably haven't used in a decade. So that is going to be a direct hit on turnout.
Okay. Well, I mean, what I hear you saying is there's still work to be done. And that actually, I think is something I want to address with you, right? So, we had the hearings in Texas, and following the October trial, the panel issued an injunction. They said, we find that Texas has discriminated against Black and brown voters and that racial gerrymandering occurred. And they issued an injunction stopping the use of the map. Now, ultimately, the Supreme Court stayed that ruling and allowed the map to go forward. And it's the map that the elections in Texas are happening right now. Despite that profound injustice, can you talk about the importance of the ruling and how you still have hope in the face of the issues that you've described?
Well, first of all, thanks to the Lawyers Committee and our team, the issue was laid out. There is no way you can refute that these are racist gerrymanders based on how people look, what language they speak. It's not about party unity or party advantage. And so I think we have a good case in terms of that. The other issue is that we are in this. We baby boomers are in this. It happened before. It can happen. It's happening again. And in my, humble opinion, I think it's worse. And I think that what is on our side is the 4.5 million African Americans in Texas, the ones of voting age since 2024, the Latino population that is exploding. That's why there's so much misinformation about citizenship and taking away their rights to vote. We are all experiencing this, and I think that the more that it happens in the White House and and at the federal level, the more it's helping our numbers grow. I'm convinced in 2024, there were 18.5 million eligible voters, and 6 million voted for the current resident of White House, 4 million voted for Vice President Kamala Harris. So that left 8 million Texans who did not vote 2 years ago. Their lives are being impacted daily by what's going on at the White House and with this administration. They're coming to vote. And if we add the 18-year-olds who are eligible to vote now, then because kids are walking out of schools, they're seeing what's happening. That's my reason for staying optimistic. That's my reason for knowing that our time is now. And I want to thank the Lawyers Committee. Texas is a huge state. We need the folk that we have now. Thank you, David and team. We need more, and we need more resources.
All right. Thank you very much, Linda. And I will turn it back over to Damon.
Wow. Thank you, Linda, for those powerful reflections and for your tireless work to protect everyone's voting rights, especially those of us, people who look like me and you in particular, and our cousins, who are so often targeted for disenfranchisement. It's just a really powerful testimony that you gave literally and also figuratively here, and the wisdom, frankly, just oozes out of every sentence. So I just really appreciate you. David, stick with us for a sec here. Your team that you're part of, voter rights litigation team, is fending off these threats not just in Texas, but also other parts of the country. Can you speak in particular about our litigation in Mississippi and what the impact has been, but also what's at stake in that case right now?
Absolutely. So, in addition to our work in Texas, myself and other colleagues here challenged the Mississippi State House and State Senate maps in 2024. And after a hearing before a 3-judge panel, we secured a victory where the court found that Mississippi had violated Section 2 of the Voting Rights Act and instructed the legislature to create 3 new majority Black districts, one in kind of the northern part of the state, one in the middle, and one in Hattiesburg. And the state complied with that and ultimately created those new districts. And in the creation, that shifted some of the other surrounding districts as well. And what we saw is that in the elections that occurred in Mississippi last year, there were new Black elected members of the Mississippi legislature. We also saw that for the first time in over a decade, the supermajority held by one party was broken. And what that means is that for the first time in over a decade, the legislature has to be responsive to the voices of Black and brown voters in Mississippi because they have to work together with these newly elected members of the legislature. And that's a profound thing. But the work's not done, right? Section 2 is under attack. The Supreme Court we're waiting for a ruling in a case out of Louisiana where they will tell us what the structures are going to be of Section 2, what it will look like moving forward. And from Mississippi, there is a pending case before the Supreme Court about whether or not individuals have the private right of action, whether or not they can sue themselves to challenge, redistricting and other things under Section 2, or whether or not that power lies with just the Department of Justice and the U.S. Attorney General. The fight's continuing, right? We're remaining vigilant no matter what the Supreme Court decides. We are thinking through all of the different ways that we can leverage the legal talents we have and leverage the networks and relationships we have with people like Linda and others to make sure that the voices of Black and brown voters are heard both in the courtroom and outside of it. And that's just kind of where we are.
Thanks so much, David. So there's a lot that could happen still in this existing Supreme Court term, which ends at the end of June, typically. We're always, as litigators, waiting with bated breath at the end of June to see what other shoes are going to drop. And frankly, there have been some really bad ones dropping in the last several years. Just to underscore what you said, David, if we get negative rulings from the Supreme Court in the Mississippi case that we're litigating, and any similar case like the one out of North Dakota, Turtle Mountain, or in the Louisiana case called Calais, what we'll be left with essentially is rights on paper, but no remedies or access to courts in fact. That would really be a cruel joke on Black people, Black voters, and on a cruel joke on democracy, frankly. Well, thank you so much, David, and thank you, Ms. Linda, for joining us. Please take care.
Thank you.
So, folks, what you just heard is a powerful reminder that the fight for democracy is not abstract. It's happening right now. It's happening in courtrooms and communities where political power is being deliberately diluted. The Lawyers Committee is there. We're there in the courts. We're there in the halls of power. We even have one of our election protection staff who lives in Texas, assigned to Texas. We have people in Ohio, Virginia, other states that we cover intentionally to make sure that we are proximate to the communities that we serve, and that we're definitely taking our lessons and cues from how they're trying to move and addressing these emerging threats. As David explained, we are seeing these coordinated efforts to weaken us, but in response, we must be coordinated too. Threats to democracy don't operate in silos, and neither can we. Protecting the right to vote today also means confronting emerging threats that exist in other realms, including emerging technologies like AI that are less visible to the naked eye, but can be deployed in ways that are just as dangerous. We all see that AI is reshaping our reality, how information spreads, how decisions are made, and how power is exercised. When voter data is misused, when disinformation floods digital platforms, and when algorithmic bias limits our options and stifles our opportunities, our democracy suffers and our people definitely suffer. As the tools of exclusion evolve, civil rights advocacy must also evolve with them. and the Lawyers Committee is doing just that. We have two of our in-house experts with us today who are at the forefront of the work that we call digital justice. They will speak with us about the issues that they're seeing and the work that we're doing here at the Lawyers Committee with our partners to ensure that civil rights principles and real people are centered and not harmed as AI takes greater hold. I'm proud to turn it over for the next conversation to Leah Frazier, Director of our Digital Justice Initiative, and our Policy Counsel, Alex Alt. The floor is yours, folks.
Thank you, Damon. As you just said, we're dedicated to ensuring that civil rights protections keep up with emerging technology. We aren't working against innovation, and the idea that civil rights protections stifle innovation is frankly a tired and historically disproven trope. What our work centers on is furthering our affirmative vision that there should be equal enjoyment of the benefits of innovation for everyone, free from discrimination. The Digital Justice Initiative has done a lot of work to tackle this on the litigation front in several different ways. Digital discrimination isn't just algorithmic bias, it isn't just exclusion. It manifests in a lot of different arenas, and our work and our job is to cover all of those. So first of all, backing up and from discussions of algorithms, AI, and emerging technology, sometimes it's not just about how technology is used or deployed on people, but it's about the digital divide, whether there's equal access to it, to the internet, and to all of the technologies that people are leveraging to advance corporate benefits and such things, whether or not those tools are available to everyday people for health, for education, and for employment opportunities. The Digital Justice Initiative is fighting for that access for everyone. We brought a case against the administration on behalf of the National Digital Inclusion Alliance, challenging the termination of a federal grant program that would have distributed over $1 billion in funding to close the digital divide. The president terminated the program by tweet, calling it a racist woke handout. Additionally, digital discrimination is about how data is exploited and collected, as Damon referenced earlier. Since the current administration came to power, we've seen unprecedented data grabs and surveillance, as well as the weaponization of data to deny benefits and civil rights, and to further the administration's draconian immigration enforcement agenda. This data exploitation and abuse has occurred in one of the highest stakes contexts, and that is voting. In case you haven't been keeping up with the latest on the DOJ's voter data grab, DOJ is seeking to consolidate federal control over elections to exert greater power over deciding who can vote and who can't. To achieve this, it sought the entire unredacted voter rolls and the voter information of every person in this country, and has sought to get that information from every single state for the purpose of consolidating controls over elections and potentially for other purposes, such as immigration enforcement. We're taking action to address these data abuses, which could disenfranchise people or chill their right to vote. And we're doing that by intervening in some of DOJ's lawsuits against states seeking to get that information. More recently, we've also taken action to protect sensitive voter data of Fulton County voters that was seized under a search warrant. In addition to all of this, Damon referenced AI, and that is the largest thing on the technological front looming on the horizon. And we've addressed this in several ways. On the litigation front, we brought a lawsuit against Meta. And our lawsuit addresses how Meta uses AI to deliver ads to platform users. Our complaint alleges that Meta's ad delivery system disproportionately targets Black platform users with advertisements for-profit educational institutions, while disproportionately targeting white platform users with advertisements for nonprofit and public institutions. A court has recognized that these causes of action are valid and denied Meta's motion to dismiss, allowing our litigation to continue. As you can tell from these cases, digital discrimination touches so many aspects of our lives, from voting to education, employment, healthcare, as well as the justice system. To safeguard communities of color from discrimination driven by AI, the Lawyers Committee policy team has been the leading champion of the AI Civil Rights Act. Here's a quick look at our work to push for this path-breaking legislation, which was reintroduced in both chambers of Congress just 2 months ago.
The AI Civil Rights Act is a first-of-its-kind piece of legislation that brings civil rights to the modern age. Right now, big tech is on the assault. They don't want to be regulated. They don't want to be held accountable.
The problem is the arms race of AI adoption, cramming AI into all of these facets of life that make critical decisions about where you can go to school, what price you'll pay for something, or whether or not you can vote.
This legislation has a few key components. First and foremost, it would have an affirmative anti-discrimination provision. We believe that existing federal civil rights laws should apply, but this AI Civil Rights Act will make it clear that AI tools cannot discriminate on the basis of race.
So this bill would give you a right to sue when your rights are violated. It would give you transparency in terms of when you're affected by AI tools. And it would give more protections to you in the designing and deployment of AI tools.
Right now, most of us don't even know all the ways that automated tools are being used in our lives. People actually have rights to learn more about how the tool is being used, what information it's using, and how that tool is trained. And then they also have rights to make sure that a human can actually make a decision instead of an AI tool.
Everyone should have clarity, rules of the road. That's what the AI Civil Rights Act will provide. Let's be in conversation together about what those guardrails should be. Let's make policy happen, not let policy happen to us.
Call your member of Congress. Tell them to be a co-sponsor of the AI Civil Rights Act today.
To learn more, visit lawyerscommittee.org.
Alex, when people hear AI, they often think about the future. But the AI Civil Rights Act starts from the premise that harm is already happening. Can you help ground us in where AI is already shaping people's lives and why civil rights law has to catch up now?
Yeah, so AI isn't the future, it's here. AI is already affecting housing, employment, healthcare, education, voting, the criminal justice system, and more. So we have a responsibility to look at its current impact. And in addition to some clear, promising, and uplifting applications, we've also seen mountains of research showing that AI's impact can be inequitable and harmful, particularly to Black and Brown communities. We've seen mortgage approval algorithms that are 80% more likely to reject Black applicants than white applicants. We've seen predictive policing software that exhibits racial bias based on historical data. We've seen major corporations that have used predictive hiring tools that have been shown to discriminate. We've seen fintech algorithms that charge equivalent Black and Latino borrowers 5.3 points higher rates for purchasing homes. And we've seen healthcare neural networks that have been shown to be half as accurate when diagnosing Black people. So these problems have either already happened or are happening right now. And while you can think of civil rights laws that can regulate these areas, such as the Fair Housing Act or the Voting Rights Act, you have to ask, how does the Fair Housing Act, how does the Voting Rights Act credibly interact with technology that its authors never foresaw? And so AI tools are frequently powered by black box algorithms that, inputs go in, inputs go out, and there's a kind of layer of plausible deniability over what's actually happening within that box. How do you show discriminatory effect, or more troublingly, intent under current laws when an algorithm is at the helm making decisions about your life? That's kind of the crux of why the AI Civil Rights Act is needed.
So for folks who haven't read a 70-page bill, can you tell us what the core protections that the AI Civil Rights Act would put into place are?
Yeah, so we start right up at the top with a strong anti-discrimination requirement that prohibits offering or using algorithmic tools to discriminate against you. Now, how do you actually enforce that? You need a paper trail. So we have auditing requirements that ensure that independent third parties are examining AI for disparate impacts before we're subjected to them, and then looking back a year later after they've been unleashed on the public, making sure that that audit is right. Okay, You've got you've got an anti-discrimination provision in law. You've got an auditing requirement. What else do you need? Well, you need strong enforcement language so that regulators can enforce the law. But more importantly, private individuals can enforce their own rights. So we have a private right of action in the law so that individuals are empowered. And then we have transparency and notice requirements because both regulators and everyday people need to know when these tools affect them and need to know their rights under the law.
Opponents often argue that regulating AI will stifle innovation. How does the AI Civil Rights Act respond to that concern? And do you think that that is a valid concern?
Yeah, so specifically about the bill, we're really careful about limiting impact to what impacts us, meaning that we're not regulating technology. We are future-proofing rights. So to put it another way, we're not anti-car, we're pro-seatbelts, or probably more apt to our current environment, we're pro-roads rather than driving through our lawns and home. And I think that's really important. We're only talking about AI tools that affect our lives in important key areas that have been brought to market. But I think generally you're kind of on to something. If you look at current attitudes around AI, according to the most recent Pew Research, only 17% of American adults think AI will have a positive impact on the US in the next 20 years. More are concerned than excited, and general attitudes about AI have fallen every year in public surveying since 2021. So if you are a developer or deployer of AI, you need a social public compact that restores trust here for both business reasons and to restore and tap into the potential of what this technology can do. If you're an industry that's already regulated, you're looking for some certainty. Will my AI tool that I want to buy do what it says it does? Is it going to violate the laws that I have to follow? Is this going to breach FAA guidelines or banking regulations? These are really important things that people want clarity on. And so to go back to the car analogy, we have the internal combustion engine right now, but we need to go to a place where we can build the interstate highway system. And so that requires safety checks and seat belts and things along the way that frankly are not the responsibility or the expertise of any one company. They're sort of social goods that we all need so that innovators and inventors can build on and profit from the great possibilities of these tools.
Clearly, this is a complex problem, but the solutions don't have to be complicated. Speaking of the solutions, though, in terms of the ones that are set forth in the AI Civil Rights Act, what role has the Lawyers Committee played in shaping the bill? And why is our voice particularly important in this fight?
Yeah, we have a unique vantage point here because we're privileged to draw from the 3 C's, which is sort of Congress, courts, and community. We have been a part of privacy discussions in Congress for years, trying to protect the data of Black and brown people online from being used against them. And because of our involvement, we saw a real policy gap of what we do about the outputs of AI tools. At the same time, our litigators, in fact, were confronting some of the same issues, seeing firsthand the impact of these AI harms on communities and plaintiffs, and the limitations of sort of existing enforcement regimes and statutes. And so we got to use our history of fighting for racial justice and our litigation expertise to generate policy ideas that are kind of on the forefront of these fights and informed our advocacy. So we created a model bill, the Online Civil Rights Act, which was utilized and adopted to create the AI Civil Rights Act. And it's been successful. Data analysis using large language models found that our model bill has been copied and used in other federal bills. So these concepts are gaining purchase with lawmakers who are looking for solutions in terms of how to address this. We've seen state bills in Illinois, New York, Washington, Massachusetts sort of use our concept and language. And we want to continue that education and growth so that both lawmakers and the public know there are things you can do right now to serve your constituents and protect civil rights.
That's a great segue. As I mentioned before, the AI Civil Rights Act was reintroduced in both houses of Congress, but it's unclear what the future holds for it. So can you tell anyone watching who cares about civil rights, democracy, and the future of technology, what they can do to help move this work forward.
Yeah, so I have two suggestions. One is for awareness to inform your conduct going forward, and one is for direct action. For awareness, I think it's really important that people understand AI is not an esoteric tech issue. Whatever your field, passion, place in life, you can claim ownership and demand that AI work for you, work for your values, work for your identity and community. We live in a bit of a Wild West. And so part of the push for adoption of these AI tools is an attempt to use individuals as test subjects. You should feel empowered to ask questions, to use the tools that work best for you and your values, and to push back. And that lends itself to the advocacy space. Frame the application of AI according to what you know and need in your life, not according to the rules of people who tell you that this is very complex or this is technocratic issue that you don't have a voice in, because that exclusion excludes the voice of the people that we need most. As with any transformative technology, we're going to need actual people with real life experience explaining and sharing how these tools affect them. So you have a voice in these issues. And then that leads right to the direct action. Please call your representative and tell them to support the AI Civil Rights Act by becoming a co-sponsor of the legislation. It's critically important that lawmakers know there are solutions for the problems that their constituents are facing and that their constituents support them. So with all that being said, we're very happy to turn things back to Damon. Thank you.
All right. Love hearing you all just be in discourse about the work, and I hope you in the audience enjoyed it as well. So, helping to ensure that no community suffers harm from unregulated AI and algorithmic bias, especially racial discrimination, is something that we just have to take on. I'm so proud of you two and how our full team at the Lawyers Committee is leading on this front. People, we've made a significant investment. We have multiple litigators and multiple policy staff who focus most of their time on these issues. So it's an area of expertise and investment that's already paying dividends. We're, developing this expertise not just for self-aggrandizement, but really to make impact. But we're proud to lead in the civil rights space on these issues. So now we've come to the part of the program where we turn to you, our audience. We have been collecting your questions throughout the program. I have a few that the team has queued up, and I want to start turning to these questions. We want to invite back in our staff, Katie, David, Leah, and Alex, to answer these questions. So our producers will make sure that we turn to them as I flag questions for them. So the first question we have is from Victoria, who asks, what can we do in this moment to help ensure free, fair, and accessible elections? It is such a broad question, but it is the question on everyone's minds as early voting is starting in some states very soon, if it hasn't already. David, let me turn to you on that one. What can we do in this moment to help ensure free, fair, and accessible elections?
I think the biggest thing that we can do is make sure that our communities know their rights and know, and if they don't know their rights, to know who to contact if they have questions. So I would say one of the biggest things we can do is promote the hotline, get the word out about the 866 Our Vote hotline, let people know if they have questions about their registration, their status, where they vote, what happens if they go to a polling location and ICE is there or they're turned away or something. They can call that hotline, and we have staff that is trained to answer those questions and help figure out the answers to ensure that they get to cast a vote. So I would say it's education, it's encouraging them to vote. That's the other part to it. All the challenges we've talked about are designed to stifle the vote, but if our votes didn't matter, you wouldn't see those efforts. And so if people get discouraged and don't go vote, then the other side still wins. And so you still need to show up. So education and then voting.
Fantastic. David, let me stick with you for a sec. So Eddie asked a question. I'm hoping to plug in as a volunteer to assist with the election protection for the midterm elections. Can you share information about how the Lawyers Committee will utilize volunteers and when we'll get started with preparations? And also remind people how they can sign up to volunteer.
Absolutely. And so what volunteers will vary slightly based on the states and the coalitions that are there. But we have volunteers that do things from, manning the hotline and taking the intake calls to going out in the field and reporting and doing updates. If you're lawyers, we have legal roving programs that you can participate in to help us with that work also. The best way to get engaged though is if you're not a lawyer and you're a volunteer and you want to get engaged, you can go to 866ourvote.org and there's a volunteer tab there and you can sign up and learn about the opportunities in your specific state and how you can get engaged. You can also reach out to protectthevote.net. That's another way you can sign up for poll monitoring shifts or election canvassing shifts after the election occurs. If you are a lawyer or a legal professional and you want to use your talents to help, you can email us at epvol@lawyerscommittee.org, and we can connect you with the relevant groups in your state, and they can help you figure out how to use your legal talents in that space. But I mean, those are the three best ways to plug in, and they're all connected to the hotline, and we can get you some more state-specific information that way.
Fantastic. Okay, let me stick on the voting rights front for a sec. So there are two questions about different types of attacks or threats. One is, what are the plans to ensure safe and secure voting sites against ICE attacks, immigration, customs enforcement, and the like attacks? A separate question, but related in terms of a threat vector, is given the administration's seizure of voting data in Fulton County, which is described as a dry run for what could happen in the future, won't we need tens of thousands of lawyers deployed to all counties where there are flippable seats, I guess competitive seats nationwide, even after we train people on election protection and election measures? So let me go to David and Leah for those questions. What are the plans to ensure safe voting sites with respect to ICE attacks, potential attacks, and deployment? And what about the ballot seizure? Do we need to have people everywhere to address that?
I think I'll start with ICE and then I'll turn it over to Leah to talk about the ballot seizure. On the ICE front, again, the plans are being determined by our partners on the ground and what the laws are in their states. But what we're seeing is, most states have anti-intimidation statutes and rules that cover intimidation at the polling location. And so in Texas, for instance, our coalition there is discussing with local officials who are not sympathetic to ICE about what it looks like to have protection unavailable should ICE show up and cause havoc. We're talking to the registrars and the officials about how to just make sure that people can vote. And some of it might look like if you are really concerned about it, voting early. So we're promoting early voting as an option so that you don't have to worry about that type of intimidation. We're also working with other national groups to help craft guidance and policies on like what your obligations are and your rights are if you're confronted by ICE at a polling location. So kind of do's and don'ts. So there's a lot of education happening. What it looks like is still in the early stages, and it's going to look different depending on where you live and where you vote. So I'll kind of stop there. I know there's a question about Fulton County. I'll turn it over to Leah because I know she's leading some of our effort work there.
Thanks, David. So the question referred to a dry run, and in our mind, that's exactly what this may be, which is why we decided to take decisive action to address the seizure of the Fulton County election records in order to protect sensitive voter information. We wanted to set a marker down and to show that we are actively monitoring and being vigilant as a deterrent to potential action in the future. And we also set forth really strong arguments about why the information seized is entitled to privacy and why that is particularly important in the context of voting rights. Because if voting becomes a vehicle by which the government can collect information about people, then it could potentially deter people from voting or registering to vote. So we're waiting to see how that litigation will play out. And we're also hopeful that the county's challenge to the seizure will cause the government to think twice about using search warrants in the criminal process as a means to intimidate voters or to rob people of their votes. hopefully, if good results come from that, there won't be a need for having thousands of attorneys deployed to various flippable seats or areas where elections are more hotly contested. We're hoping that taking decisive action earlier on will go a long way in terms of prevention.
Leah, let me stick with you. Thank you for the response, and also thank you to Gail and Ellen for submitting those two questions. But let me stick with you, Leah, on another question. Can you elaborate how you're thinking and how our team is thinking about privacy rights being foundational to protecting marginalized communities in the age of AI?
Sure. All of the discussion about voter data shows that data privacy in general is important and foundational to our civil rights. But in terms of artificial intelligence, data privacy is really at the heart of everything. We're acutely aware that artificial intelligence incentivizes collection of mass amounts of data about people and also enables analysis of that information at scale, which enables the government to surveil communities. And we all know that Black communities and other communities of color have always been the target for that type of surveillance. A lot of our work recognizes data privacy issues during an age of rapid AI deployment. If you take our Meta litigation, it's evident there that Meta's ad delivery system was able to target certain demographic groups with different types of ads because of the data that it had amassed and collected about people. We're also taking a hard look at government AI-driven surveillance tools, which not only rely on data exploitation and privacy violations, but also perpetuate them. As an example, we submitted a FOIA request regarding ICE's use of facial recognition technology to get at some of these issues. In addition to litigation work, we're also committed to public outreach and messaging to enable people to protect themselves from digital surveillance. Some people might think that that is tilting at windmills, so to speak, because of how much information there already is about people, but there are measures to mitigate that. And so we're working hard on multiple fronts to ensure that people can protect themselves in addition to the work that we're doing on the litigation front.
Thanks so much, Leah. That question came from Jasmine. Alex, let me bring you in. There's a question from Kyle as follows. Investments in AI and AI-related infrastructure like data centers made up a significant part of overall economic investment over the past year. How might changes in the regulatory environment shape economic output, and how can we commit to equity? So it sounds like there's a question really about the kind of guardrails we're talking about. What does that mean for economic output and activity? And how can we, ensure that there's equity in this economic activity?
Absolutely. This question actually hits a little close to home. I don't know if folks on this call know this, but my brother's an electrician, and he's working on building his third data center right now. So there is clearly a powerful economic impact that, I'm grateful for, as, I'm glad my brother's making a livelihood and being part of this economic boom. On the other hand, though, the reason he's on his third data center is that one of them fell apart because it was a fraud to investors and violated labor laws. And so I think that there is a real kind of need to have some baseline protections and regulations that help ensure that this growth is sustainable and productive for us going forward. If you think about our legislation, we're not focused on environmental impacts or the actual physical construction of data centers, but it's pretty analogous in that what we're looking at is what is the impact on people in their most crucial areas, whether that's, where you go to school or what your job is. Can we have some baseline protections in those areas so that we can harness this promise? And I think those safeguards give folks trust in these tools and lead to a more sustainable future with them that lets us harness that economic growth.
Thanks so much, Alex. Very, very thoughtful. Katie, let me get you into this dialogue now. So Mary asked the following question about DEI. So you and I are in this fight. Our team's in this fight. But Mary asked a really interesting question. She asked, why wasn't there more of a national and state organized pushback against the elimination of so-called DEI projects. It appeared in Florida that Black organizations and programs just accepted this as the law, a total reversal of remedial programs. What would you say to that, Katie?
Yeah, that's a great question. Thank you for it. I think my answer would be that I think when DEI was rolled out, that I think a lot of our movement maybe took for granted that it was something that everyone would see as beneficial, and that it wouldn't be as controversial as it became. And it sort of got wrapped up and conflated with the affirmative action measures that were challenged successfully in the Students for Fair Admissions Supreme Court case. It got kind of wrapped up with critical race theory and the attacks on that, and so it sort of all became enmeshed in this sort of backlash that, frankly, I think is built on white resentment. And it's very dangerous. It's something that we have to take seriously, because going after DEI is really the gateway to going after our core civil rights protections. This is a way to weaken our civil rights laws and protections themselves, like disparate impact theory and other forms of discrimination, claiming that our very laws and protections, our very remedies, like DEI measures, are anti-white and anti-male. So I think that from the get-go, we need to do a better job of informing and educating everyone about what this is and what it isn't. So that's one. But now we're here, and there are many of us that are pushing back and are organizing. So in Florida, in particular, there were 2 lawsuits that were successful to challenge the Stop Woke Act there that Governor DeSantis passed or signed into law. One was Honeywell versus DeSantis, and that was brought on behalf of private employers, because that anti-DEI state law went so far as to reach into private employment and to really chill the ability of private employers to give trainings on bias and even things like harassment. The other thing is that, and like I said, both of those cases were successful, and the Honeywell case was upheld on appeal by the 11th Circuit. Also, in some places, students have protested quite successfully, at minimum getting attention on the harmful impacts that these state anti-DEI laws are having. So we saw some students walk out and walk to the Capitol in some southern states when their legislatures were passing these anti-DEI laws to talk about, what this meant for their ability to feel safe and included in campus life. And lots of people are trying to continue the work. So that, I'm so glad Damon mentioned the Protecting and Advancing DEI Pro Bono initiative. We continue to see a demand from grassroots nonprofit groups that are engaged in racial equity. They want to continue the work, and they want assurances, and they want to know how to do that in a legally defensive way. The needs for these programs are still there, and we're ready. We stand ready to help these organizations continue to meet those needs. And I think ultimately that we are getting smarter and going to build back smarter. And that, while we're going through this very terrible and painful backlash right now, that things will change, and that we'll have more data sources to support, more evidence to support the need for race conscious and remedial programs that will actually have a more meaningful impact in people's lives. So I am hopeful for the future, and we continue that fight.
Thank you, Katie. We have so many great questions, but we're running out of time. I'm going to pitch one last question to the full group. This question comes from Linda, excuse me. And the question is, because there's so many, all of you are brought as attorneys, and whether you do litigation or policy, but then also we have many people in the audience who are lawyers as well. The question from Linda is, what's the most impactful action that individual lawyers can take right now? So if y'all could riff on that, would appreciate it. Anyone feel free to jump in too.
I would say contact our lawyer volunteer information on the hotline, the EP Vol at Lawyers Committee. And that is a great way that we can help you use your legal talents to help ensure that people have the fair access to a vote. And we're always looking for great lawyers and who have time to help leading up to and on and even after Election Day. So.
Great. All right. Well, we're going to leave it at that. Thank you so much, Katie and David, Leah, Alex. You're a cross-section of our wonderful team at the Lawyers Committee. Thanks for all that you do. I'm proud to be your colleague. I get to talk about the great work you do every day. Thank you. All right. So thanks also to everyone who submitted questions. Sorry we couldn't get to all of them. There's so many great ones, but it is close to time for us to close now. But I first want to give a big thank you again to the presenters. Thank you to our special guests, Jane Valinga and the legend, Linda Lewis. I also want to express my gratitude for you dedicating your almost 90 minutes of your time to this set of conversations today. We value your curiosity, your interest, and of course, your commitment to the work. We are very proud of what we accomplished here at the Lawyers Committee in 2025. So we did look back on that, but as you can see, we're clear-eyed about looking forward to 2026. We understand what the demand is. We understand the necessary vigilance, courage, and resolve. I hope that everyone leaves this event today with a deeper understanding of what's at stake in 26 and the years ahead. I hope you have a better sense of what it means to be resilient in these challenging times and to stand up to the modern-day Goliaths that we're fighting. The Lawyers Committee and our brave clients are proof that discrimination cannot and will not go unchallenged. As all of our speakers demonstrated today, even in the most threatening and challenging of times, we will not retreat. We will fight back. We'll build the record along the way, and we will also fight forward. This work is urgent, but it also requires staying power, and it requires your support. As you've heard today, new threats evolve as newer technologies emerge. Democracy does not defend itself. It's not self-executing. That's why your partnership and your support matters to us so much. You help us to stay in these fights, to get into the fights and to stay in these fights, and you help us to win. In the coming days, our team will publish our 2025 Impact Report, which provides a detailed look back at the major priorities and the impacts from last year, but also a look forward to what we're trying to accomplish this year. Everyone who attended or signed up for this webinar today will receive a copy of that. It'll also be on our social channels as well. We hope that through the report and through what you heard and learned here today, that you're inspired to remain invested in the work of the Lawyers Committee. Someone asked at the end, one of the questions was, what can lawyers do now? I turned that into, what can anyone do now? We need your investment. We need your support. We need your human capital as volunteers, whether you're a lawyer, whether you're not another kind of professional. We need your reputational capital when you talk about us and align your own brand with our work. We also need your fiscal capital. We need the dollars to make this work run. So your charitable gifts fuel our fight as a nonpartisan, nonprofit organization. You can please scan the QR code that you're going to see on the screen shortly, or you can visit our website at lawyerscommittee.org, www.lawyerscommittee.org to contribute. So just thank you so much from the bottom of my heart. It is the privilege of a lifetime to be at the helm of this organization. It is the honor of a lifetime to work alongside these amazing advocates. And it is a gift of my lifetime to be able to make impact for, with, and alongside people like you. Thank you so much for your time today. This struggle continues, and we're so glad you'll be with us. Take care.